Good afternoon, everyone. Welcome to our July 11th webinar on amending your governing documents best practices. My name is Elena Gilbert and I am presenting today. So hello, everyone. Before we get started, I am going to go through a few housekeeping things, and to entertain you as I'm doing this, you may enjoy this meme. Although honestly, a lot of times I wish we could set some of these documents on fire because they're that bad. Okay, real quick. So if this is your first time doing this webinar, the bulk of the screen should be the PowerPoint. Okay, and to the left is a screen with your presenter, me. Hello. So you should be seeing both of those. If you have questions while we are doing this webinar, you can go to the chat icon, the private chat icon, click on that and type in your questions. I will get to them at the end of the presentation, time allowing. I always want to make sure we can get through all the materials first and then do as many questions as we can. So if I'm not responding to it, it's not because I don't have it, it's because I'm waiting till we get through the materials. If you are having any audio, video problems, there's nothing I can do on my end, but you do have a little button there at the bottom that asks you if you're having audio or video issues. And click on that button and it'll run through some things and hopefully fix whatever the problem is so that you can continue to participate and listen into the video. 1 CMCA credit is going to be generated for you attending this webinar. So that will be emailed to you automatically. It's typically done within, I don't know, either today or tomorrow. You should be getting it via email. If you don't see it in the next day or two, please reach out to us. You can actually email me directly at egilbert@altitude.law. And that email will also be up at the very end of the presentation, so you have it. So feel free to email me if you haven't received your credit. Otherwise, you should see it. If you are, we always get the question of, are we recording these videos? Yes, these webinars get recorded, and by Monday, it will be on the YouTube channel for ACE, Altitude Community Education. So you can go to our regular website, go under Education, and then on the right-hand side, there's going to be a YouTube channel link, and you can click on that, and we record pretty much all our webinars, the ones that we do that are the daytime ones, and they're on there, and you can watch any one of them. You just won't get credit for it if you're watching it not live. Finally, last but not least, there will be a survey at the very end. For those of you who have done these webinars, you're used to that. It automatically pops up. For those of you who have not done the webinars, it will pop up. So I personally am really, really asking if you have time and inclination to fill that out. It's the only, well, not only, but it's the main feedback we get for these presentations, and it lets us know kind of where we can improve, what you guys like, what you guys don't like. So please, don't be shy. Just let us know your thoughts. All right. So without further ado, we have a lot of stuff to cover today. And so I want to get started. So document amendments right now are hot, which I can tell just based on how many folks have signed up for this webinar. We've got over 400 people who signed up for this. That tells me it's hot. Usually we're anywhere from like 150 to 200. A lot of associations are looking at amending their documents for different reasons. We're seeing a lot of amendments for insurance type issues because premiums are getting so high. We're seeing insurance amendments based on CTA compliance. We are seeing it all over the place. So it's a hot, hot commodity right now, which is why we are doing this informational, wonderful class. So before I get started on the details, when we talk about amending the documents, there's lots of documents that associations have that can be amended, right? Here's a list of a few of them: the declaration, the maps, articles of incorporation, bylaws, rules, policies, resolutions, guidelines, etc. There's all sorts of documents that govern our HOAs. And any one of them it is possible to amend any one of them. The question is, how do we do it and what does it take? So as I started putting this webinar together, it occurred to me that there is just so much information in this that we really are not going to have time to focus on all the documents that can be amended. So the primary focus for this class is going to be the declaration. That's really the hardest one to change. That is the one that most of our communities are focusing on right now, is amending the declarations. And the other things are all important, but I just don't think we're going to have time to do all of them. So we're going to focus primarily on the covenants, although we are going to talk about some of these other documents in passing. So kind of the first thing to look at is, what do you need to amend your documents, right? I mean, the board can't go and amend all their documents on their own. It doesn't work that way, especially when it comes to the declaration. So why is the declaration so important? It is so important because this is the document that impacts our homeowners' rights. You may own your property and it may be, your home is your castle, but only to the extent that the covenants say so, right? Because the covenants, the declaration, it's all the same document, right? CC&R's Declaration of Covenants, DEX. This is the document that tells me as a homeowner what I can't do with my property because I own it within this common interest community. It also tells me things I have to do with my property because it is part of this common interest community. So otherwise, I wouldn't have these types of restraints or requirements on my property if I didn't live in an HOA. So my rights as a property owner, which are very, very important, are curtailed by this document. And this is why the declaration gets recorded with the county. So it is of record. It's a real estate record. It binds people, whether or not they got a copy of it, whether or not they read it, whether or not they know it exists. Legally, they are on notice of everything in this document, and they have acquiesced to complying with everything in this document. So when you have owners saying, well, I never got a copy of this at closing and nobody ever gave it to me, that's all irrelevant. That they are still just as required to comply with it as anyone who did get it, who did read it. So that's why it's so important. This is our property rights we're talking about here. And it should be very difficult to amend because we don't want, a 5-member board being able to change everyone's property rights just because they want to. And so the way that this is drafted, so as you know, we have the Colorado Common Interest Ownership Act, KIWA, and KIWA says there is a specific range of homeowner approval that is acceptable when it comes to amending the declaration. At the low end, we have a majority of all owners. Now, that does not mean 50%, right? It means more. It means 50% plus 1 unit. It does not mean 51% because a majority can still be less than 51%, right? So be careful in how you phrase this. It's a majority. That's all. On the high end, we have 67% of all the votes. Okay, so it's not just of those who show up, it's of all of them. And this was a change to KIWA. We didn't have these limitations, originally. And it got to the point where we had associations that just weren't able to amend their documents because they had such high amendment requirements. And so this was a change, a legislative change that occurred kind of after KIWA was adopted to help assist with situations where we have unreasonably high homeowner approval requirements. But of course, as you know, 67% of all your votes is still a really, really high approval requirement, and it's not easy to get. Okay. Sometimes we see other approval requirements for covenants, right? Sometimes we see first mortgagee approval requirement. So what's a first mortgagee? Well, that is the bank that each homeowner pays their mortgage payment to. So if I don't flat out own my house, I'm paying someone a monthly mortgage payment. And whoever that is the first mortgagee. So sometimes we see requirements that a certain percentage of the first mortgagees approve an amendment to the declaration. So I've got a story for you on this one. It's virtually impossible to do that, to get that. I had a community a few years back. It was a 12-unit condominium complex, and they had an approval requirement of 100% of the first mortgagees. Okay. And they said, we want to try and get this approval. There's only 12 units. Shouldn't be that hard. We should do it. Well, after 2 years of trying to get mortgagee approval, we got 7. Okay, out of 12. Didn't happen. Did not happen for them. So I'm only telling you this story to show you that if you see a first mortgagee approval requirement in your covenants, don't fret, we can get around it, but we're not going to be able to get those banks to approve because they just don't care. The other possibility of approval is sometimes, especially with newer communities that have just maybe recently transitioned from developer control, we see approval of the declarant as a requirement. So it'll typically say something like, until the declarant no longer owns any property in the community, the declarant has to approve all amendments. So that is not as difficult to get. Typically, when we're amending a set of covenants and we have a declarant, we can typically get their buy-in as long as we're not taking anything out that they put in there to protect themselves. So again, that one's not as hard. Let's talk about some other documents and approval requirements before we get into the nitty-gritty of all of this. So your maps, that's your plat maps, your condominium maps. They are, for all practical purposes, Kiowa defines them as part of the declaration, which means they have the same amendment requirements. We know they're not part of the declaration. We know they're a separate document, but they are also recorded documents. And they also bind homeowners and whatever property rights they have. There's usually a lot of notes in those documents. There's easements that are set forth, and sometimes a whole bunch of other information. And that also does bind our homeowners and the associations. So they are considered to be kind of on the equal playing field as our covenants. And so to amend a map, we really are looking at the same approval requirements as we are for the declaration, except that in some cases, we also need to go through a municipal process, which is a whole other ball of wax. And it just depends on what type of an amendment you want to make. If you want to get rid of like a public easement or a public right-of-way, obviously that's something you're going through the municipality for. If it's a matter of we want to add another tennis court and we just need to add that to the depiction of the community on the map, that's different. That one we will not likely need to go to the municipalities to do. Articles of incorporation. Usually the default is it's a majority of those who are voting, as long as you have a quorum of homeowners voting. Okay. Bylaws is the same thing as the articles, except that sometimes we can actually amend the bylaws with just the board approval. There is a provision in the Nonprofit Act that says the board has authority to amend the bylaws unless that is specifically prohibited in the bylaws themselves. So if you have a provision for your amendment that says these bylaws may be amended by a majority of quorum of homeowners, something like that, and that's all it says, that is not actually a prohibition on the board being able to amend them. It's just an option. These bylaws may be amended. Now, if it said something like these bylaws may only be amended by the homeowners, that would be a prohibition. So there's a lot of leeway there with our bylaws where the board has authority to amend. There's certain things the board's never going to be able to change in the bylaws, no matter what. Quorum is huge, so can't change quorum. If it's a post-Kiowa community, you also can't change, things like director terms, board qualification, board powers, things like that. So it's a question of what are we trying to change? When was the community created? And can we do this with just a board vote? Rules, policies, resolutions, like I said, guidelines, all that good stuff that falls under that kind of bottom category, as I like to call it. That is board, right? That is something that the board does on its own, majority board vote, unless something higher is required. But otherwise, it's the board. And the caveat, what's the caveat though with all these documents is, one, it cannot conflict with anything that is in these other documents that are above it. Can't conflict bylaws, articles, declaration, map, can't conflict with that. And it can't conflict with the law, can't violate the law. So those are kind of the caveats. And as we move on here in a minute, we're actually going to talk about situations in which an amendment might be better than a policy or a rule, or when a rule might be better than an amendment. For those of you who have been through a declaration amendment before, you know it's not quick, you know it's not easy, unless you have a very small community that's tight-knit and everyone agrees. It is not an easy task to amend the declaration. We're going to talk about that process in some detail as we go. But for those of you who have done it, you know that probably the most difficult part of it is getting your homeowners to approve, right? Getting their buy-in. And we're going to talk about that in some detail. But first, let's look at this. So what is it that you're trying to do with a declaration? That's what really allows us to decide whether it is better to amend or whether it's something we can do through a rule or policy that the board can adopt. So the question is, and we're going to go into these specifics, are you changing the declaration or are you clarifying it? In other words, are you trying to define something that's already in the declaration, or are you trying to add something new? Are you creating additional restrictions that don't currently exist? If you are, most of the time you are going to have to amend. Are you adding board powers? Are you deleting provisions? What is it that you are doing? If all you're doing is clarifying and expanding, you do not need to do that through an amendment for the most part. That is something that can be done via resolution or rules. So let's take a look at what we're talking about. All right, so here's some examples. And this first one is one I always like to use because we see it in so many documents. A declaration might say, an owner can have a reasonable number of household pets. What's a reasonable number? For me, it's infinity. I would like to have all the animals in the world come live with me. I think a reasonable number is as many as I want. I suspect that's probably not the definition others have. Some other folks might say, well, it's 2, it's 3, depending on the size of the community, depending on the size of the units, whatever. That's a reasonable number. But the point is, it means different things to different people. And so it is not clear when you read this provision what it means. And the board can adopt a resolution that says a reasonable number of pets is fill in the blank. You put a number in there. That is what we define to be a reasonable number. And that is something that can be done through a rule or a resolution, because we're not changing anything that the declaration says. We are simply clarifying and defining a specific term that is used. What's a household pet? All right, dogs, cats, that's easy enough. What about my pet python? I actually do have one. I have a Burmese python. She's about 15 feet, about this big around. I love the girl. Her name is Quinoa, in case anyone cares. But is that a household pet? Should I be able to have that in your community? What about a potbelly pig? What about chickens? There are people who have some pretty exotic animals, like I have a giant iguana. So, are those household pets? Are those typical household pets? Do we want to define in a rule what a household pet is and what we will allow, what we won't allow? So those are all good questions to ask, and these are all good candidates for a policy or a resolution or a rule to define these terms. Now, let's say you have a board that says we want to adopt a rule that says a reasonable number of household pets is 0. Do you think that's going to fly? Well, it won't, because when we have a provision in the declaration that says you can have a reasonable number of pets, that means you can have pets. And so to define that term as 0, what we're essentially doing is saying you cannot have pets. And that directly conflicts with this provision that says you can have pets. It just has to be a reasonable number. So, be careful. Sometimes boards get very creative, and we always want to make sure that our creativity isn't coming back to bite us in the booty later. How about this one? No boats in the community. Had an association, and this is a true story. It was years ago. It's a single family home community. It was by a reservoir, very close to a reservoir. Everyone in that community had a boat. Well, most everybody had a boat. And you could see the boats. The houses weren't that far apart. People could put them in their driveways or on the streets or whatever. But that community also had a set of covenants that had a provision that said no boats. I don't know why the developer put that in there, but it said no boats, even though they created the community right by the lake. Okay, so board's like, we're not enforcing this. This is fine. And a new homeowner moves in and decides he's going to read the covenants because he doesn't like boats. And he sees this provision and he lets the board have it. You are violating your duties. You're not enforcing the covenants. It says no boats. So the question the board had was, well, can we just adopt a rule then that says you can have boats because this provision no longer applies, we're by a lake, blah, blah, blah. Well, the answer was no, because you are changing the declaration. You are taking a specific provision that prohibits something and you're changing it to allow that same thing. That is a direct change, and that can only be done through an amendment with your homeowners approving it. Okay. Condominium unit. How many times do you have a condominium declaration where the condominium unit is defined as everything within the interior finished surfaces of walls, floors, and ceilings, but none of that is defined? Like, what's an interior finished surface? Does that include the drywall, or is it the finished surface on the drywall? We're not entirely clear. Another good candidate for a resolution to define what the term means. No hazardous activities inside units, same thing. Unsightly objects, same thing. Short-term leasing, can we prohibit it via rule? All right, so here's the thing with leasing. Leasing is kind of on its own plane. It is considered to be a use restriction. We don't have a very clear definition of what a use restriction is, but pretty much everyone agrees that if you're going to regulate leasing in any way, shape, or form, that is, you are directing homeowners how to use their property, and that is a use restriction. Kiowa says you, the board, cannot impose any use restrictions without approval from at least 67% of the owners or any higher requirement your declaration might have. So you want to prohibit short-term rentals in your community. It's not currently prohibited in your document. So it's very clear that this need can only be done through a declaration amendment that the homeowners approve. Now, let's say you have an older set of covenants and it requires approval from 75% of all owners to amend. Now, normally we would say this goes down to 67% because that's the cap we just talked about that Kiowa sets, right? Okay, but when we talk about use restrictions like leasing, it does not go down. It stays at that 75%. Why? Because Kiowa says use restrictions can only be modified by at least 67%. So even if you have a lower requirement, you still need 67%, or a higher requirement if you have one in your covenants. So that is an exception to the rule of majority to 67%. This is an exception where we can go above 67% for approval, where we can be required to go above. So when you are talking about amending your documents and you've got a board that really wants to change leasing, that's all in good. Just know that they're going to need to go through at least 67% of the homeowners. Okay, I want to talk about the actual amendment process because that is definitely something that we should all be aware of, at least as far as the general steps go and how it all works and what the options are. I'm going to just go step by step here and talk about each one. Okay. Preparing the amendment. So that's the first step. Obviously, the first step is determining the determination by the board that we need an amendment, right? So it's going to go through the analysis we just talked about. It's going to consult legal counsel to say, this is what we want to see happen. Is this something that requires an amendment? And let's say they come to the conclusion that, yes, we need to do a declaration amendment in order to be able to make this change. Okay, so you need to know what changes are needed, right? Now, sometimes your documents are so old and so outdated, we just say scrap them and rewrite it. Get a brand new set of documents in there. Your covenants are from 1975, long before Kiowa was even in existence, right? Let's just scrap the whole thing and get you updated modern documents, and we'll start from scratch. And you, the board, tell us what you need. So to do that, to figure out what you need and to get your amendments drafted, whether it's a small change to the covenants or it's a rewrite, I absolutely positively recommend you engage with counsel to do it. I'm not saying this because I want to make more money, because if I wanted to make more money, I would say do it yourself and then have the attorneys review it, because that costs more money than actually having the attorneys do it. I have quite a few boards that they think they're going to save money, and they say, we're going to do the initial draft, Alina. I say, okay, it's probably going to cost you more than if I do it. And they're like, yeah, whatever. At the end of the day, it does cost them more. It takes me more time to review and correct things on a document than to just draft a document myself, which is why we end up spending more time and incurring more legal fees when we're doing it that way. It might be counterintuitive to some folks, but believe me, that is how it turns out. All right. So you engage with legal counsel to prepare the amendment. You as the board have to be comfortable with the amendment. You need to read through it when the attorney gives it to you. You need to understand what it says. I'm always happy when I prepare a draft of an amendment when a board comes back to me and asks me to do revisions, because to me that means they've read it and they've thought about it, right? So remember, these are going to be your governing documents, not mine. And I, as the attorney, am doing my best to get you what you want and in a manner that complies with the law. But you need to be able to look at them and say, this is going to work for my community, or no, this will never go. And that's something that we as the attorneys rely on you for when we are drafting these amendments. Several drafts will likely be necessary, especially if there is a board that is very involved in reviewing the covenants and editing the amendments. Usually we see a few drafts before we go any further. If you are completely rewriting your governing documents, one thing that we do at least is When we get you brand new documents, homeowners will say, well, can we get a red line copy of these documents? Because we don't know what's changed. Well, the problem is we can't redline a brand new document. It's all brand new, right? So we can add annotations to those that say, like, this paragraph is similar to paragraph X of your current documents. This is new paragraph, it's required by Colorado law. And basically we annotate these new documents so the homeowners and the board have a point of reference as to where did all this come from, and is this what we currently have, or is this something completely different? So if you are rewriting, make sure you get the drafts that are annotated so that you can kind of navigate through them and be able to review them with some sense of, okay, I understand if this is new or this is not. Owner buy-in. Honestly, this is the hardest part, and I said it earlier on. Owner buy-in is by far the most difficult piece of the amendment process. I think I'm probably preaching to the choir here, but it's so difficult to get owners to agree to anything, much less 67% of anything, right? Getting 2/3 of your homeowners to approve something, given all the personalities, given all the things that different people have going on in their lives, don't expect it. Don't expect to get it. Okay? Don't expect that everyone's going to love what you're proposing. Even if most people love it, you're always going to have those naysayers. People who you never thought would be, you know, the problem children, so to speak, they come out of the woodwork. Because whatever it is, we've hit a button with them, whether it's we want to do short-term leasing now. Well, wait a minute, I may need to do a short-term rental. It's my right as a homeowner. And you never know what's going to get people. We have ideas just based on experience, but you just never really know. So don't expect your homeowners to just come in and love everything you're doing. Even after you've gone through several drafts, you've talked to the owners, you've sent letters, you've had meetings, don't expect your naysayers to go away. There will always be some naysayers. The key here is we want very few naysayers to the point that we can get the document passed and get the approval we need for it to pass, right? How do you get buy-in? Well, obviously, you're going to want to have to send out your drafts to the homeowners. Once the board is comfortable with the draft, you really want to send that out to your homeowners. Give them time to look at it so they can ask questions. Give them a portal to write in their questions. Have a meeting with your homeowners to talk about it. Sometimes people get upset only because they don't understand what a provision is saying. They think it says, I can go into your unit anytime I want, when all it really says is I can go on your lawn and water your grass if you're not doing it. So sometimes these owners get upset, and it's because they don't understand. So it's always a good opportunity during a meeting to explain, this is what this really means. A lot of times the boards have the attorney who drafted the document attend the meetings so that they can explain. And understanding, once homeowners start to understand, they start to think about the amendment in a different way. And then it's, well, what about this? And what happens of this? What happens of that? And those are all good questions. Those are all things that homeowners need to understand, because these are documents that are going to impact their rights, right? So the other thing I like to tell boards who are going through this is expect that you might have some deal breakers. In other words, if this provision that we proposed stays in your governing document, stays in the proposed amendment, you may not get the approval you're looking for. I have seen associations proposing complete rental bans, for example, in the governing documents. No units may be rented at all. And they've had to take that out of the drafts because homeowners were so opposed to it that they knew they would never get anywhere remotely close to what they needed if they kept that in there. So you will discover some deal breakers. So keep an open mind that you may really, really want something in your new documents, and we put it in there, because we want it in there, but you may end up having to take it out or modify it because there's no way you are going to get homeowner approval with that provision in there or with it in there the way it's currently written. So don't go into these meetings, into these, homeowner buy-in situations thinking that you're going to get everything you want. It's a negotiation just like anything. Okay. So the buy-in process really, I think, starts almost right away, and it keeps going until the very end because we need to keep getting homeowner buy-in to get the approval. So eventually we get to the point where it's time to vote on the document. Yay, right? You think, thank God we're here, we're going to vote. So let's talk about voting options because this is also a fairly complicated, I want to say, matter. So there's two ways to vote. One is we hold a meeting, people go to the meeting, they vote at the meeting. We don't generally recommend voting on covenant amendments at a meeting because the chances of you getting a majority of all your owners or 67% of all your owners to show up if you're a decent sized community is virtually zero, right? I mean, I don't know how many of you have tried, but it's virtually zero. And the problem with voting at a meeting is it's a one and done situation. You call the meeting, you don't have enough people showing up to approve your amended and restated declaration, meeting's adjourned, you're done. Now you got to start again. What does that mean? Well, now if you're going to do it at a meeting again, now you got to send out all new meeting notices. So you're basically incurring fees every time you call a meeting, and you're not going to get to where you need to be because the chances of, like I said, 67% of all your owners showing up, pretty slow. So because of that, we generally recommend the mail ballot option. The technical term for it, it's in the Nonprofit Act, is a written ballot, which I think is kind of stupid because all ballots generally most of the time are written ballots. So why not call it a mail ballot? Because that's really what it is. But anyhow, that is the option we generally recommend. Why? Well, because essentially it allows us to have a voting period of about 60 days, 2 months, right? So that gives time for the association to send reminders, to make phone calls, to knock on doors, to create a committee where you're soliciting people to return their ballots. Whatever it is you want to do to politic, to try and get people to submit their ballots. And 60 days is a lot more time than one single evening, right? So that's really, I think, the main reason why we want to go to do this via mail ballot. A few things to consider with a mail ballot is, again, I'm going to recommend you have your attorneys draft the documents. Why? Because the Nonprofit Act has some very specific provisions and requirements for what needs to be in the ballot solicitation letter and the ballot itself. I've had boards kind of try and save some money. They draft it themselves. They send it out. They get the requisite approval, only to be told, sorry, this was not a proper vote. You didn't include all this other stuff that you were supposed to include in your mail ballot packet. So I encourage boards to use their legal counsel when you're going through this process. At least that way, it's going to be done correctly and within the confines of what the law requires. So one of the things that's required is when you send your ballot solicitation letter, it has to have a specific deadline when ballots have to be received, not mailed, but received by the association to be counted. And when I say specific deadline, I mean a date and a time, okay? So what that means is the board, before everything gets mailed out, needs to figure out, A, how much time are we going to give owners? Are we going to do our full 60 days? Or do we cut it off at 30 days because we think we can get approval? My recommendation is usually full 60 days because I have seen communities that say we can do it in 30 days, we can do it in 45 days. Let's just do that because we want to hurry up and get it done. And then They get to the 30-day mark or the 45-day mark and they're nowhere near where they need to be. And the question then is, well, can we just extend the deadline to the full 60 days? And the answer is no, no, no. You cannot. Statute doesn't allow you to extend the deadline. Once you set it and you send out that letter, it's done, it's written in stone. Another issue that sometimes comes up with these mail ballots is homeowner really upset. They think this is a horrible thing to do this amendment. They fill out their ballot. They say, I'm not approving this. They send it in. And then later on, they get talking to their neighbors and they're like, oh, maybe this isn't so bad. Maybe I should approve this. And then they want to send in a corrected ballot. With a mail ballot process, can't revoke what you've already submitted. Once the association receives the ballot, it's done. You can't change it either way. Okay, so those are things to remember with the mail ballot process, which is why you want to give it enough thought ahead of time so that you set an appropriate time frame and that your homeowners are aware that, hey, once you cast your vote, it's done, it's over with, you can't change it. And so ultimately, we're going to use one of these methods. There are some out-of-the-box thinking ideas out there that I know some attorneys use. I don't want to get into those because I don't know that they always work, and two, they're kind of convoluted and complicated, and this is confusing enough as it is. So ultimately, like I said, my personal preference is just to do a mail ballot vote. All right, let's move on. A couple things we need to talk about. These are ancillary processes that Kiowa has created for associations that have trouble getting what they need to get their new documents passed. Now, let me first say this is only applicable to declaration amendments. This is not applicable to your bylaws, to your articles, anything else. It's just your covenants. Okay? So, when would we use these processes and how do we know which one to use? Now, some of you who are on here probably have already gone through some of this stuff and you have experience with it. So make sure you're telling, your fellow managers, your fellow board members, hey, I've gone through this before. Here's what it looks like. It's important. So let's look at the certified mailing option first. And let Newman tell you about certified mail, right? All right. So certified mailing, when would we use this? The only time I would recommend using certified mailing is when we have a first mortgagee approval requirement and you have already obtained the necessary homeowner approval. So you have a 67% owner approval requirement. You got it. You got the 67%. Congratulations. Now we just have this first mortgagee approval process lingering in the background because we know we're not going to be able to get it just by sending out notices. So if we got our 67%, we can use the certified mailing option. And what it requires is a certified mail to all first mortgagees, which is going to include our voting packet. So it's going to include the amendment. It's going to include the cover letter. It's going to include a ballot. Okay? And that gets mailed by certified mail to each first mortgage holder. So you're going to incur fees doing that, obviously. So you can kind of do the math in your head. If you've got a brand new set of documents, 60 pages, plus 2 more sheets of paper, certified mail, how much does that cost, times how many homes, or how many mortgagees are there in our community. Now, the first question I usually get is, how do we know who the mortgagees are? And that's a great question. The answer is that information is obtained. Typically what we do when we're handling these is we go to a title company and have them pull ownership encumbrance reports because that identifies who the first lien holder is. The problem is if you have a huge community, it takes a while because title companies are somewhat behind in pulling this information. They're just slammed. We had a community, a master community a couple of years ago that we were doing this for. I think it took about 8 months to get all the O&E reports. It was crazy, but it was huge. It was a very huge community. So it doesn't usually take that long. But if you've got like 200, 300 units, then, it could take a few weeks to get that from the title company, but that's how we get it. So anyway, so you send that to your banks. After that, you have to publish notice of the amendment. So you don't have to publish the entire amendment, just, hey, we are looking for approval from first mortgagees of this amendment. You have to publish that notice at least twice in a local paper, and it has to be at least 1 week apart. So essentially 2 weekends or whatever in a row, you're publishing it. And after that, we wait 60 days. A non-response is a yes. Okay, so if a bank doesn't respond, which is normally what happens, then it's an automatic yes. And this is a good way to get your mortgagee approval if it's a requirement and you can get all your homeowners to approve. The only time I worry about this particular process is if I have an association that has approval requirements of 100% of the first mortgagees. Because in that case, even one no response kills it for us. So otherwise, I think this is an absolutely wonderful way to go. Court petition. When do we need court petition? By the way, I love this meme so much. It just makes me laugh. And I don't know if it's because I'm a lawyer and a geek or if you guys think it's funny too, but I think it's hilarious. All right, court petition. So this one we use when we cannot get all the homeowner approval and or first mortgagee approval. So this one kind of addresses both problems for us. So if we have a 67% homeowner approval requirement and we can't reach that, we can use the petition process as long as we've gotten half of that requirement. So DEC says 67%, we got 33.5% of the homeowners saying yes. That's the threshold to be able to petition the court. So it's not half of the owners, it's half of what the declaration requires. We can petition the court without first mortgagee approval. Again, this is a way to get around that. But a couple things you can't do when you're using the court petition process. One is you cannot change your allocated interest. So if we have weighted voting, for example, and we want to go to all equal voting, you can't do that if you're petitioning the court. The court cannot approve that kind of an amendment. You can't terminate the community through a court petition process either. Okay, so those are the things we cannot do. But there's certain things we also have to do before we can petition the court. So we have to send at least 2 written notices to all our owners that says we are working on an amendment, keep an eye out for it, heading your way. I mean, it doesn't have to be a lot, but it just has to allow owners to know that we're working on this. So 2 written notices. You have to hold at least 1 meeting with your homeowners. So this can't be a board meeting at which homeowners can attend. It has to be a homeowner meeting. And at that meeting, we need to have time to discuss the amended and restated declaration, whether it's a Q&A or the attorney's there to talk about it, whatever works. But you got to have at least 1 membership meeting. Okay. So statute says if you do all these things, then the court has to approve your amendment. The judge does not get to read the amendment and say, I like it or I don't like it. They don't have that right under the statute. What they have to do is see if you've complied with all the requirements of the statute. And they have to approve it unless 1/3 or more of the homeowners file objections. So all homeowners get notice of the petition. That is a requirement under the statute. So when we're filing the petition, we send notice to all owners saying, we're filing a petition, you have the right to file an objection. We have to give them that notice. And so if 1/3 or more of your homeowners file an objection, it's going to be dead. Judge can't approve it. So the court petition is absolutely awesome when you have apathy in your community. It is very dangerous if you have a strong opposition to the amendment. Because if you have a very strong opposition, Those owners, they're going to go door to door and they're going to get signatures and they're going to find a third of the homeowners and they're going to file that with the court and the judge will say, sorry, I can't approve this. So again, before making the decision of whether or not to petition the court, it's also important to look at your community and to see, are we suffering from apathy here, or are people just really, really adamantly against this? The other thing that could happen is if 1/3 or more of the first mortgagees file objections, judge will not approve it. So if you have a first mortgagee approval requirement, when we file the petition, we have to send notice to the mortgagees in addition to the homeowners, and they can file an objection. I have never seen 1/3 or more of the first mortgagees file objections. They don't, like I said, they don't even look at this stuff. I've seen 1 or 2 file objections. That's generally not going to be enough to reach 1/3. And so I have not seen a court petition defeated on that level. Finally, if you have the declarant approval requirement, that you have to get approval of the developer, and the developer objects, even if they've given you their approval, they then object, which doesn't typically happen, but if they do, court cannot grant your petition and they cannot approve the proposed changes to your declaration. And then it goes away again. Last but not least, recording. We talked about this early on, right? The declaration is a recorded document, which means it puts everyone on notice who purchases in the community, and legally they acquiesce to complying with everything that is in that document. So once the declaration passes, it gets signed, it gets notarized, and then it gets recorded. In this day and age, everything gets recorded electronically. We no longer have to walk down to the clerk and recorder's office and physically hand it to them. We're filing it electronically, which also means we don't need the original signatures. So for those of you, who are going through this, once it's approved, all you got to do is sign it, scan it, and send it to your attorney so they can record it. And the amendment is only effective when it's recorded, not before. It's not when you get the votes. It's when it's recorded. Then you can start using it, not before. Oh my God, that was a mouthful. And we have a few minutes left. We're going to do some questions. I hope no one young is offended by this. I thought it was hilarious. Again, my humor. It's weird. Okay. We have, I see there are like 54 questions in here. You guys can't see them, but I can. So I'm going to try and go from the top and go through as many as I can. Feel free to email me after if I didn't get to your question, or if you don't get your CMCA certificate, here's my email address. Okay, so we got a question. If it's a community's pre-Kiowa and the declaration says 80% of owners to amend, do they have to do 80 or does the 67% apply? So the 67% applies, even if it's pre-Kiowa, unless you are doing an amendment to change leasing or something else that will be considered a use restriction. Then it's going to be the 80%. What happens if you don't update your documents? Well, I mean, nothing really happens, but what is going to happen is there's going to be provisions in your documents that conflict with the law that your boards can't enforce. And they're going to need to figure out which ones those are and make sure that they're not enforcing them. They might also be lacking in some specific authority to do something that they could add if they amended. So their life just might be a lot more difficult depending on how old their documents are. If owners do not approve changes to the declaration, Kiowa has a provision for, so we just talked about it, that's the court petition process. All right. If we have 100 owners, but only 87 of them vote, is a majority 67% of the, are we talking about 67% of the 100 or 67% of the 87? It's 67% of the 100. It's everybody. 67% of all the votes in the association, regardless of how many folks vote. All right, 2 questions here. Let's see. When a covenant amendment is physically mailed to homeowners, are there restrictions on collecting the votes? i.e., can community members walk around and encourage voting and collectible ballots? And does the law regulate this? Yes, people can walk around and encourage. And that could be homeowners who are against the amendment can walk around and like try to convince people not to approve it. And board members can walk around and try to get owners to approve it. There's, I know there's like some theory out there that board members aren't allowed to politic, and that is absolutely not true. If the board is presenting this amendment, you absolutely can go door to door, you can have meetings, you can do whatever to try and explain to people why this is a good idea. Question 2, we recently submitted an amendment survey of interest to our board, but our lawyer said that the board couldn't modify the amendment before sending it to the community. Is this consistent with the law? I think it depends on kind of where they are in the process. If they're just trying to put a first draft of the amendment together, the board can certainly modify it until it's comfortable with it. If we're at the point where we're already voting on it, then we can't change it midstream because people are already voting on it. So depending on where they are in the process. Great. All right. Does a non-mandatory HOA need the first mortgagee approval to change the CC&Rs? So the first mortgagee approval is only needed if your documents require it. The law does not require it, whether you're pre, post, or not subject to Kiowa at all. That only your documents can require. So if your current documents don't have that, then that's not a requirement. There is a lot of original declarant language in the current CC&Rs that are disclaimers and boilerplate text to protect the developer. Yes, we see no reason to keep that, and it's being eliminated in the revised CC&Rs. Do you agree with that? Yes, absolutely. That is like the first thing we do when we rewrite documents is we want to eliminate all that superfluous language in there. It doesn't mean anything. It doesn't apply anymore. No reason to keep it. Is the declaration the same or different is the CC&Rs? It's the same thing. Like I said, it's the declaration, it's the CC&Rs, it's the covenants, it's the declaration of covenants, conditions, and restrictions. It's all one document. It goes by many names. Let's see. Can board terms be changed by board only in the bylaws for pre-92 associations? Yes, they can. That's the short answer. Yes, they can. Oops, sorry. So there's a section of Kiowa that indicates non-required good governance policies. Some of those are significantly subject to the legislative change. Can those 9 policies be developed as rules? Yeah, so rules and policies are treated the same way. They have slightly different purposes. The policies, like rules, are adopted by the board, they're amended by the board, they're repealed by the board, and the 9 required policies you are referencing in this question is, they're adopted by the board. Can a 55 and older community create a rule specifying when and how many guests can be at a unit if the declaration is silent on the matter? You don't want to regulate how many people are in the unit, but you can regulate how many guests are allowed on common area, and that's regardless of whether you're a 55 and over community or not. So you could say no more than 3 guests at the pool, or on common area, or in the playground, or whatever amenities you guys have. So you can do it that way. I don't think you can really do anything as far as how many guests they have in the units at any given time. So if the board chose not to enforce the boat policy, but that one owner wanted to create a stink about it, guess the end result would be that he could file a lawsuit. Yes, this is back to the covenants that did not allow boats. Okay, I'm going to do one more because we're running out of time. And so those of you who I don't get to, again, please feel free to email me directly. We recently modified our rules and regulations to comply with state laws. Are there state laws that would impact required change to our declarations? There's never a required change to the declaration in Colorado. You just have to know what you can't enforce anymore. So no, you're never legally required to change your declaration, but you are legally on notice of provisions in your declaration that conflict with the law that you should not be enforcing. So that's the difference. Okay, in the interest of time and respecting everyone else's time, thank you guys so much for attending, and we will see you next time. And again, feel free to email me with questions. I'll get to them as soon as I can. Thanks.